Hi, everyone, and welcome back to the Texas Business Court Insider. My name is Kate Ergenbright, and I'm here today with my partner, Rachel Roosth. Today, we're going to be talking about the Texas Business Court's recent decision in Enosis Investments versus Jensen, which every practitioner handling LLC disputes in Texas should read carefully. Now, the Business Court issued this decision pursuant to Texas Rule of Civil Procedure 166G, which is a procedural tool the Texas Business Court has been using to decide legal issues like the ones that we're going to discuss today early on in a case.
That's right, Kate. This case centers on several LLCs established for a real estate project. They had a complex ownership hierarchy, co-managers, and a business arrangement that ultimately devolved into legal disputes. Now, Kate, you and I have identified 4 takeaways from this case that apply directly to how we structure, draft, and litigate LLC disputes in Texas. So can you start us off with the first takeaway?
Sure. The first takeaway is that a litigant that wants to establish the existence of a joint venture can't just state that a joint venture exists in their pleadings. They have to actually allege facts that support the elements of the existence of a joint venture, which is a question of law. Now, the court held that the plaintiff in this case failed to meet this pleading burden because there was no allegation that the alleged joint venture members agreed to share profits and losses, which is an element of a joint venture under Texas law. Now, setting this pleading issue aside, the court went on to explain that the plaintiffs also couldn't rely on the relevant LLC agreements to establish the existence of a joint venture, because those agreements unambiguously disclaimed the creation of a joint venture or a partnership.
The court identified 4 specific provisions in those agreements that, taken together, conclusively foreclose plaintiff's joint venture or partnership theory. The first provision stated that the LLC itself is not a joint venture or partnership. The second stated that no member or manager intended to be a joint venturer or partner of any other. And the third stated that the agreement shall not be construed to create a joint venture or partnership. Now, those provisions all sound very similar, but each one targets a different nuance of a potential joint venture or partnership argument.
And the fourth provision of the LLC agreements that the court discussed is the entire agreement clause. That provision confirmed that the LLC agreements at issue were the entire deal between the parties and superseded all prior or contemporaneous agreements. The clause eliminated any argument that a party's understanding or an oral agreement created any joint venture obligations outside the 4 corners of the LLC agreements themselves.
Right. So for drafters, this opinion gives you a concrete checklist. All 3 of those disclaimer provisions, plus that entire agreement or integration clause, can assist in defeating joint venture allegations.
And Rachel, this drafting lesson connects directly to our second takeaway, and that is that Texas is committed to freedom of contract. Now, the business court in this case was unequivocal. Where sophisticated parties had every opportunity to structure their relationship differently, the court held the parties to the specific language and structure that they chose in their LLC agreements. The court held that it would not, for instance, interpret one of the LLC agreements to support an alleged oral agreement that directly contradicted the contract's express terms.
The concept of freedom of contract is not new to Texas practitioners, of course, but Enosis provides an important reminder about the practical impact of the LLC drafting process, particularly as the business court continues to use Rule 166G to resolve these issues at earlier stages of litigation. But let's move on to takeaway 3, which is that there is no inherent fiduciary duty owed by a non-managing member to the LLC. One defendant, South Fork, was a member of the LLCs, but was not a manager. The court confirmed it could find no statutory authority supporting such a duty, nor was there a contractual basis for such a duty in the LLC agreements.
Rachel, I think the contrast between a member-managed LLC and a manager-managed LLC is important here. In a member-managed structure, the managing members exercise control over the LLC, and unless waived, typically they owe the LLC fiduciary duties as a result of that control. And in analyzing these issues, the court was careful to address and respect the choice of the LLC members at issue and how they actually just structured their entities as manager-managed LLCs and not member-managed LLCs.
Right. Now, Kate, I think we're ready for the fourth and final takeaway, which is that the Texas Business Court will uphold corporate separateness in the absence of a properly pleaded veil-piercing theory. In this case, Jensen was the president and controlling owner of Braverman. That's the entity that served as a co-manager of the LLCs that are at issue here. But Jensen himself was neither a member nor a manager of those LLCs. Nonetheless, the plaintiffs argued that Jensen's control over Braverman gave rise to a fiduciary duty running from Jensen directly to the LLCs.
That's right, Rachel. But the court rejected that theory, characterizing the argument as an attempt to disregard corporate separateness and impose the fiduciary duty owed by the managing entity Braverman on its officer and shareholder Jensen. The court noted that the plaintiffs in this case had not offered or cited, and the court had not independently found any support for imposing a fiduciary duty in this context. Texas courts, as many practitioners know, don't recognize new fiduciary duties lightly, which the court acknowledged, and the court declined to recognize the new fiduciary duty here, explaining that ignoring the choices of the sophisticated parties in this case and how they structured their business entities would be contrary to Texas public policy.
The court did preserve one important limit. Corporate separateness does not shield someone from their own independent tortious conduct. So, for example, fraud and knowing participation in a breach of fiduciary duty remain available theories, but they must be specifically pleaded with supporting facts.
The through line across all four of the takeaways that we've discussed today is the same. The importance of precision, whether that's in how an entity is structured, in the drafting of an LLC agreement, or how you plead your case. Because the Texas Business Court is going to hold sophisticated parties like the ones at issue here to the deals that they make.
That's right. Well, that's all we have for today. To our audience, thank you for joining us again on Texas Business Court Insider. Please make sure to like and subscribe so that you receive notice of our next video.